Good afternoon, everyone. Thank you for joining us today. I'm Len Gordon. I lead the advertising and marketing group at Venable. I'm joined by my colleague, Mary Gardner, who's a partner in that group. And we're excited to speak with you today regarding payment processors and the regulatory crosshairs. We're providing an update on the regulatory scrutiny facing payment processors and provide some best practices for compliance so as to avoid getting crosswise with very active regulators. Give me the next slide, please, Mary. Thanks. So to start, we'll start with first principles and talk a little bit about how the FTC does what it does. The FTC conducts investigations using civil investigative demands, sometimes access letters to request information from merchants, processors, and others. Sometimes the FTC decides to challenge conduct using its internal administrative proceedings before an ALJ. Those findings of the ALJ can then be appealed to the commission and then to a district court. Sometimes the FTC goes to district court directly using its authority under Section 19 of the FTC Act, which allows the FTC to go to court to obtain redress for violations of rules that the FTC has promulgated or for certain statutes, for example, the Restore Online Shoppers Confidence Act. The FTC can also use Section 19 subsequent to an administrative trial if they can prove that the conduct at issue was such that a reasonable man would have known it was false or deceptive. Certain times the FTC refers matters to the Department of Justice where the relief sought is civil penalties. The FTC does not have the ability in most cases to directly pursue civil penalties. The FTC has recently dusted off its penalty offense authority pursuant to Section 5 and 1B of the FTC Act. It's a unique authority. So if the FTC were to litigate an administrative case and get a consent order against Mary and declared that Mary doing XYZ is illegal, which is highly probable, they could then, if Len knew about the XYZ conduct that Mary had been found to be violative of the law, the FTC could sue Len for violating essentially Mary's order. This was an authority that the FTC used in the 70s and 80s and then put it on the shelf instead using Section 13B, but with the demise of Section 13B, which I'll talk about in a second, this is an area where the FTC is becoming more active. Currently, there aren't administrative litigated cases finding payment processors liable. Now, the FTC may try and stretch some of its other authority to reach a payment processor, but so far that hasn't been a tool the FTC has used. In other instances, for cases involving endorsements, earnings claims, the FTC has actually sent out penalty offense notices to broad swaths of industry to put them on notice so that they could then come back and perhaps seek penalty offenses if they find people are violating those orders. Section 13B is what the FTC had historically used for monetary relief in the last 25 years. The Supreme Court found last year that provision authorized only injunctive relief, not monetary relief. There have been proposals in Congress to remedy that. We'll see if that actually happens. There's been bills in both houses. They've gotten some traction, but nothing close to passing yet. All right, let's go to the next slide, please. So what legal theories does the FTC use when it pursues payment processors? The Federal Trade Commission Act does not have an aiding and abetting provision. And based on the Supreme Court's decision in the Central Bank of Denver case, the ability to infer an aiding and abetting claim is limited if the statute doesn't expressly provide for that. That hasn't really slowed the FTC down, however. What the FTC does is use its unfairness authority. And the unfairness authority is broad and vague. An act or practice is unfair when it's likely to cause substantial injury to consumers, which is not reasonably avoidable by consumers themselves and not outweighed by countervailing benefits to consumers. And what the FTC typically alleges in cases against payment processors is that the payment processor providing a merchant with access to the payment system and then processing those payments is in itself an unfair act or practice, so the liability isn't aiding and abetting liability, rather it's direct liability by the processor. There have been lots of challenges to this, saying, chargebacks are a means by which the consumer could avoid the harm. Courts have not looked typically very favorably at those arguments, but they will continue to be pressed, I bet. The FTC makes broad use of the telemarketing sales rule. There is a provision in there that outlaws using remotely created payment orders as payments or services sold through telemarketing. And there's also a provision there that provides that when a person substantially assists or supports a telemarketer and knows or consciously avoids knowing that the seller or telemarketer engages in an act or practice that violates the TSR, here that would typically be making deceptive claims in telemarketing. The FTC will use that provision of the telemarketing sales rule to go after the processor frequently. And with that background, I'm going to turn it over to Mary to talk about the first of the cases we're going to discuss today.
Thanks, Len. So just last week, the FTC approved a settlement order with Electronic Payment Systems. A little background on that case. Electronic Payment Systems is an ISO, an independent sales organization. They're the intermediary between the merchant seeking to open a merchant account and an acquiring bank. And initially, the FTC sued EPS as well as its owners in federal district court in the District of Arizona in 2017. And that case alleged both unfair practices and TSR violations. Essentially, the FTC said EPS facilitated a merchant's unlawful telemarketing scheme. And the FTC sought to recover a little over $4.5 million from EPS, which they said was the total amount that EPS collected from credit card transactions minus refunds and chargebacks. That's a typical calculation that we see the FTC trying to use when they're trying to recover from payment processors. Both parties aggressively litigated the case, and then in the aftermath of the AMG's decision that Len mentioned, the District of Arizona, although ruling that the EPS defendants, oh my gosh, I'm so sorry. That's trying to look at my notes. Although ruling that the EPS defendants violated Section 5 and also assisted and facilitated the merchant's TSR violations, found that the FTC was not entitled to the $4.5 million in equitable monetary relief under Section 13B in the wake of AMG, and also, very interestingly, found that the FTC was not entitled to a permanent injunction because EPS had ended its relationship with the merchant, and the FTC had not been able to provide any evidence of additional violating conduct in the 6 years since it had filed the case. So past misconduct plus no evidence of a likelihood of recurrence indicated that an injunction wasn't necessary to the court. In the wake of that decision, the commissioners voted to file an administrative complaint against EPS and certain of its owners. And the allegations in that complaint dealt with credit card laundering. And specifically, the FTC alleged that EPS, through its independent sales agents, falsified merchant applications, opened merchant accounts for straw owners and hiding true identities of who the merchants were, and that EPS then processed transactions through these merchant accounts even after they had evidence that the account should have been closed due to red flags and indicators of fraud. So for example, one fictitious company was called D&D Marketing, and the supposed owner was one of the merchant's employees who had those initials, but the account was actually for the merchant money now. On March 15th, the FTC and EPS entered into a proposed consent agreement to settle the administrative complaints. Under the provisions of the FTC Act, that settlement was on the Federal Register and available for public comment for 30 days. And on May 12th, the commission voted 4-0 to approve the settlement. A little interesting facts about the settlement: because of AMG, there's still no money. There was no monetary component to the account, but it does contain several very interesting screening, monitoring, and injunctive provisions. So there were a lot of restrictions on the types of merchants that EPS can now process for. So no shell companies, no misrepresentations regarding the type of business. And in fact, there were they were entirely and then there are also enhanced screening provisions for certain categories of merchants. And that included any merchants who were doing telemarketing, debt collection, money-making opportunities, as well as consumer credit companies, rental leasing agencies, and job listing services. And if a merchant falls within one of those categories, then electronic payment is required to do additional review of the type of business that they're marketing, including looking at their marketing and websites, really digging into the ownership structure to ensure that, you know, there are no fictitious or straw owners, and reviewing any kind of transaction that where the consumer is not physically present at the merchant location, as well as looking in depth at chargeback rates. It also put in place monitoring requirements once one of these merchants that fell within one of these heightened scrutiny categories was onboarded as a client. So EPS is required to regularly monitor merchant websites and telemarketing scripts for any signs of unfairness or deception. They have to investigate consumer complaints. They have to monitor transactions for any kind of unusual trends, you know, really high volume of transactions and then cut off after a 3-month period, or really large or a really large transaction. They also have to monitor merchant account use. So they have to make sure that a merchant isn't opening multiple accounts, using them for short periods of time, and then closing them or letting them go dormant. Chargeback rates, that's going to be a theme we see a lot of today. They have to calculate chargeback rates on a monthly basis, and they have to initiate an investigation, which includes a secret shopping component, if chargeback rates exceed 1% in any 2 of a 6-month period, or if there are more than 55 total chargebacks in a month for any 2-month period of a 6-month period. So that's a pretty hefty monitoring requirement. And the last interesting component of the settlement is the requirement to monitor your independent sales agents. A lot of these cases, particularly EPS, included a component of the allegation saying that, you know, the independent sales agents that EPS was using were bringing in bad actor merchants, and that EPS wasn't appropriately policing that conduct. And so as part of the settlement, EPS has to actively monitor its sales agents' existing portfolio to look for any bad actors. And it also has to look at past referrals. Now, if EPS determines that any sales agent has previously referred or currently has with the company a merchant that the agent knew or should have known engaged in unlawful conduct, EPS has 3 days to terminate their relationship with that independent sales agent after uncovering that knowledge. And Len, I'll turn it over to you to talk about the next case.
Sure. So 2 quick notes on the EPS case. One, you may have wondered why the FTC didn't bring a claim under the TSR and Section 19, since there was a TSR claim in the administrative complaint. It's because the conduct was so darn old. A lot of the underlying conduct here had happened in like 2013, 2014, and the Section 19 has a 3-year statute of limitations. Also, with regarding to monitoring ISOs, that's a recurring theme you're going to see. The FTC really expects processors to closely monitor their ISOs, although it's a slightly different business model. If you're trying to figure out what the FTC expects companies to do, the EPS case is a good example, but there's also a case involving Yellowstone, which was in the merchant cash advance business. They got their leads through and signed merchants up through ISOs, and there are some pretty strict requirements there regarding dissemination of the order and monitoring, because the FTC is not going to accept that, well, the ISO is responsible for the underwriting, that they are going to look up and down the chain at the merchants. So let me talk now about Universal Guardian Acceptance, UGA. UGA provided financing for students of an entity called Online Trading Academy. Online Trading Academy provided education on how to make money in the stock market, how to beat the stock market, how to limit loss. They got sued by the FTC and settled quickly thereafter. UGA is also working with other companies in the alternative education space. The FTC alleged that UGA knew or should have known that OTA was deceiving consumers. And in the complaint, they rely heavily on documents from UGA's file, noting complaints from consumers, suspicions that people had at UGA, complaint rates, cancellation rates. And the FTC put that all together and said they knew or should have known. And because they continued to provide this funding, it enabled OTA to continue to do business, and that by providing this funding, that in itself was an unfair act or practice. Again, in this post-AMG world, the remedial approach that the FTC took was imaginative. It didn't order UGA to pay money to the FTC to give back directly to consumers. Instead, the settlement orders UGA to forgive debt for impacted consumers. And I suppose that's defended as it's not monetary relief, it's an order directing UGA as to how it must act regarding, in the future, more like an injunction regarding existing debt. Now, money's money, but that was sort of an imaginative way that the FTC got around its not being able to get equitable monetary relief as a result of the Supreme Court's decision in AMG. There are some monitoring requirements. One of the things that I wanted to focus on here is the cancellation rate. So in the complaint, they talk a lot about the cancellation rate being as high as 12%. And the order requires that UGA investigate any instances where the complaint rate or cancellation rate exceeds 5%, or there are 50 cancellations or complaints within 2 consecutive months. I find this troubling. I think a processor could rely to some extent on the fact that consumers are canceling to show that the merchant had a cooling off window, and that if people who had purchased it decided they didn't want to go forward with this, they had the opportunity to cancel their financing and cancel their subscription to the education. You would certainly expect that if no one was able to cancel after they first signed up, the FTC would take issue with that. And I think it's one of those instances where you're damned if you do and damned if you don't. It's very similar to refunds. FTC frequently looks at evidence of a high refund rate as evidence that the merchant is doing something illegal as opposed to providing good customer service. And again, that's one of those situations where it really puts a processor in a tight spot. With that, I am going to turn it back to Mary to talk about the next case.
Right, so automatic funds transfer services is a great example of how the FTC is bringing enforcement cases against payment processors after AMG. So automatic funds transfer is just a TSR violation. There's not even an unfairness claim in the complaints. And the FTC alleged that Automatic processed consumer payments for what they alleged was a fraudulent student loan debt relief scheme, and that was the violation of the TSR, including the TSR's advance fee provision. The red flags, it's kind of a textbook list of the red flags that the FTC tends to focus on. The FTC highlighted that the merchant had very high return rates, that there were a large number of consumer complaints, that certain of the merchant accounts were opened with fictitious companies and owners, and that there were pretty readily apparent violations of the TSR that Automatic's compliance officer had flagged in memos, but had not been otherwise addressed. The parties ultimately settled, and the settlement contains a really imposing ban. Automatic is banned from payment processing for debt relief services and student loan entities. So that's a really aggressive ban. And we were just looking at the last case, the FTC's requirements on investigating cancellation rates with 5% when they exceeded 5% or 50 cancellations. Well, the chargeback monitoring rates for Automatic, the investigation trigger, is really small. If the total rate exceeds 2.5%, or a monthly rate exceeds 1%, or 40 chargebacks, that's a really 40 chargebacks can be a really small number, and this to me seems like a very sensitive trigger to initiate an investigation, and could be viewed as putting a really large burden on a payment processor's compliance department to trigger investigations as frequently as this could, especially if you have high volume merchants. There was a monetary component to this settlement. There was a total judgment of about $27 million. Most of that was suspended due to inability to pay, and they were ultimately ordered to pay $500,000. And with that, I will turn it back over to Len.
Thank you, Mary. So the next case is a case that actually Mary and I defended for iStream Financial Services. iStream was processing remotely created checks for a couple of discount clubs that were marketed, at least according to the FTC, to people who had applied for online payday loans and got bounced down a ping tree and ultimately ended up at the discount club membership. The FTC alleged that consumers thought they were applying for a loan and instead were getting enrolled in a membership. Whether they're ultimately ever going to be able to prove that, I think, is a different question. That case is continuing. iStream settled. The FTC alleged that by processing these remotely created checks, iStream had committed unfair acts or practices. There was also some telemarketing, and the FTC used its authority under Section 19 for that telemarketing that was still within the statute of limitations to receive relief that way. The settlement, the FTC, not surprisingly, took an aggressive position on settlement. The company had to agree to stop using remotely created payment orders, including remotely created checks. Also agreed to get out of certain lines of business. And there are very stringent screening and monitoring requirements, both for front-end and ongoing business, including things you would typically see in both screening and monitoring. You're reviewing marketing materials, searching law enforcement and other databases, things like the match list. But what was also interesting is the screening requirements, which were very aggressive. The company had 90 days to scrub its entire portfolio against those screening requirements, and that 90 days is up soon. If during monitoring or this rescreening, there is a finding that one of the screening filters got tripped, whether it's something on a gripe site, or there are certain thresholds regarding chargebacks or dishonored checks, whatever there's several different screening thresholds in there. The company has to immediately commence an investigation, and if they're going to continue to process for that particular merchant, they have to have something in writing which explains by clear and convincing evidence why the issue that was triggered in the screening does not, in fact, indicate that the merchant is acting in either an unfair or deceptive manner. And I will tell you that actually requiring that in writing is, to some extent, doing the processor a favor, because one of the issues that you frequently see is issues in a file that say, hey, this merchant's got a problem, and it gets addressed, people talk about it, but the file isn't well papered as to why the merchant was allowed to continue. You saw that in the UGA case. So by requiring the processor to document the decision to continue, you're sort of almost helping the processor protect itself. The FTC had originally sought over $40 million against iStream, so the settlement for 2.3 was a relatively good deal. The director of the Bureau of Consumer Protection, Mr. Levine, was unhappy and let everyone know that because of the AMG decision. Let's go to the next slide, please, Mary. Thank you. So we were talking about how the FTC has been imaginative and clever in trying to get around the roadblock that the Supreme Court put in its ability to get equitable monetary relief. It looks like one of the ways they're doing that is to try and use receivers to do what the FTC cannot do directly. Tom McNamara is a lawyer on the West Coast who frequently serves as an FTC receiver. It's his primary way he makes his living. He was named as the receiver in two different cases that the FTC brought, one against Triangle Media, another against Apex Capital. Both of those companies were in the negative option nutraceutical business, free trials converting to subscription plans. Both got sued, both got shut down. Mr. McNamara then sued Wells Fargo, who was the bank for both of those defendants, in a single complaint, alleging that Wells Fargo had aided and abetted fraud, violated the California unfair competition law, and several other violations. The complaints focused on ignoring red flags, including shell companies for a high-risk business, the free trial nutraceutical space, high chargeback rates, and that the monitoring violated the Wells Fargo's own policies and procedures. I find it a little scary that a receiver is doing this. You would typically think that a receiver who stands in the place of the companies for which he or she is the receiver would be charged with the bad acts of the corporation for which he or she is the receiver, and therefore these types of claims would be barred by the doctrine of impari delicto, equal fault. The receiver seems to have gotten past that issue. I think probably by arguing that the people who owned the corporation were essentially acting outside their authority because they were operating the corporation illegally, and therefore the corporation should not be charged with the illegal actions. Seems to me that's pretty imaginative lawyering, but the case is continuing. Most of the claims that the receiver brought were allowed to go forward. The claims of negligence and receipt of stolen property were kicked out, but everything else is moving forward. And the receiver in that case is seeking essentially the difference between the judgments that the FTC got and the assets that it received when those cases were settled on an ability to pay basis, essentially the suspended portion of the judgments against the two corporate entities. So whether they ultimately prevail, we'll see, but it's a scary scenario, I think, because the receiver is acting, he gets paid based on what he recovers essentially. So he's almost like a little plaintiff's lawyer out there in this instance. And again, the FTC is going to continue to be resourceful in trying to get around the hole in its authority. And with that, let's talk about another aggressive agency, the Consumer Financial Protection Bureau. So the CFPB, it's been around for a little while now. It's got a new leader, Rohit Chopra. He is an incredibly aggressive enforcer, and he is using all of the tools in the CFPB's ample toolbox. It has more tools than the FTC. The CFPB can get monetary relief. It can get both civil penalties directly. It can get them in administrative litigation, at least until that law gets changed, perhaps soon by the Supreme Court. It also has the authority to issue what are called market orders, similar to the 6B orders that the FTC can authorize, but to study markets. And it has used the authority in the payment space, sending, I would call blunderbuss subpoenas, CIDs, to the large platforms regarding how they process payments. And they read like antitrust CIDs from the Justice Department or the Federal Trade Commission. And it's clear that the CFPB is viewing its role not just as a consumer protection agency, but also as an antitrust agency on the payment space. Exactly where that ends remains to be seen, but they aren't hiding what they're concerned about there. The CFPB can send warning letters, they can conduct investigations, they have authority over not just the Dodd-Frank bill, but also any provision of federal consumer financial law. They can litigate in federal court. They can also litigate administratively. They've just revised their administrative adjudication provisions to provide the director has even more control over that litigation. They also have supervisory authority, and the CFPB under Dodd-Frank has the power to assert supervisory authority over non-bank entities that has reasonable cause to determine are engaging or have engaged in conduct that poses a risk to consumers. That's a pretty loosey-goosey standard in my view. They are using that authority. I don't know if they're using it directly against payment processors, but they are certainly, we're aware, using it against companies that are very close to the payment processing space. Payment processing is an activity that's clearly within the enforcement authority of the CFPB, but now they're trying to, looks like, bring it under the supervision and examination authority. Let me go to the next slide, please, Mayor. Thank you. So the CFPB does have aiding and abetting authority. They call it assisting and facilitating. So it can use that authority against payment processors. It can also use unfairness authority, very similar to that which the FTC has. It can also enforce the telemarketing sales rules. So it can use the assisting and facilitating provisions there. The CFPB can also use advanced fee prohibitions, debt relief, and some other services as well. So the CFPB has a really robust toolbox, and it is using it. They've been bringing cases, as Mary will talk about in a second, all over the place, and payment processors clearly are one of the tools that they are, one of the targets that they're considering, excuse me. Let me turn it back to Mary. Oh, before I forget, the CLE code, compliance 2022.
So one of the recent cases that the CFPB has brought and settled is with respect to RAM payment and its predecessor account management systems were debt relief payment processors. And the CFPB investigated the entities for violations of the CFPA and the TSR related to their relationship with both traditional debt relief merchants and student loan debt relief merchants. A little more detail, AMS and RAM provided account maintenance and payment processing services to consumers. And the CFPB alleged that they provided those services to about a total of 270,000 consumers over the course of the relationship. The CFPB released its investigation findings. They found that RAM violated the TSR's advance fee provision by collecting fees for debt relief services before those debt relief services came to fruition, that they violated the CFPA by allegedly falsely representing that they were an independent third-party company, even though the owners of RAM and AMS owned one of the financing companies that RAM and AMS were working with. And then they also alleged that the RAM failed to return unearned fees after consumers had canceled services. On May 11th, the parties entered into a consent order, and pursuant to that order, RAM agreed to pay an $8.7 million refund to consumers who were enrolled in student loan debt relief services. And that 8.7 million, the CFPB calculated that 8.7 million by saying it's the amount of the unrefunded fees charged and any unrefunded fee payments for the student loan debt relief services. As Lynn said, the CFPB has the ability to collect civil penalties on its own as well, and it exercised that right here. It collected $3 million, and that money is being put into the Bureau's Victim Relief Fund. It also includes some pretty hefty industry bans. AMS and the two owners of AMS and RAM are banned from the industries they were working in: debt relief, payment processing, and account maintenance. RAM, which is the still operating company, its ban was a little less arduous. They're banned from providing services and receiving funding from affiliated financing companies. So they can still operate it in the space, provided they do so legally. And interestingly, Len was just talking about the CFPB supervisory authority. One provision of the consent order is that RAM consents to be under the Bureau's supervisory authority. So, we may see that in action soon. Len?
So Brightspeed Solutions, you can think of this one as sort of the perfect regulatory storm. It takes two things that the consumer protection regulatory community hates. One, remotely created checks. The agencies hate remotely created checks because they are not subject to the NACHA thresholds and NACHA system to flag and prevent excessive returns, or they're not really chargebacks, they're returns. And online tech support, which has been a consumer protection point of emphasis for years. You have seen the FTC bring several cases against online tech support companies. You've seen the FTC bring several cases against payment processors that did business with online tech support companies. You have seen the Department of Justice criminally prosecute some companies that were involved in processing payments for online tech support and companies involved in online tech support. So the word to the wise is that if you are going to process remotely created checks, you should really vet incredibly carefully why that merchant is doing it, because the view of the FTC, the CFPB, probably the Department of Justice, and the states is that this is a scoundrel. This is a merchant who doesn't have any other means to take money from consumers. It can't get a merchant account for credit cards. It can't process through the ACH rails because its return rates are too high. So if you're going to be processing remotely created checks, I would be extraordinarily careful who you're doing that for. Similarly, if you are going to be processing, in online tech support, you should be really careful who you are processing for. The view of the regulators, again, is that most of the companies that are marketing online tech support are scammers. They think that they're all boiler rooms located in India that are scaring old people into buying either malware or worthless software that does little or nothing to improve the function of people's computers. So That's why I call this the perfect storm. Brightspeed positioned itself as a processor for high-risk telemarketing business. I would advise companies to be careful how much they tout their being able to process for high-risk business. The FTC, the Cfpb look at those kinds of ads and gives them an idea who they ought to be thinking about as potential investigatory targets. Here you had very high complaint volume, including directly to the processor. You had return rates 22 to 24%, and concerns voiced by banking partners. The Cfpb alleged that the processor failed to do the vetting and monitoring necessary for this kind of business. The case resolved through a stipulated judgment, banned from payment processing, consumer lending, deposit taking, and financial advisory services, essentially out of the consumer financial business. Banned from engaging in debt collection and telemarketing in connection with consumer financial products and services. Mr. Howard was ordered to pay a $500,000 civil money penalty to the Bureau's Civil Penalty Fund, and then there was a $54 million judgment that was suspended because of inability to pay. But that's, that's a pretty big judgment. All of which says if you're going to be in these kinds of lines of business, you need to be extraordinarily careful. And with that, I will turn it back to Mary.
Now, the MoneyGram case, which is currently pending, the response to the complaint is actually due tomorrow, is a joint enforcement effort between the CFPB and the New York Attorney General. And MoneyGram is, a fund transfer business. So not a payment processor, but within the non-banking financial space. The CFPB alleged that MoneyGram violated a host of consumer financial laws, including the CFPB, CFPA, EFTA, the remittance rule, and the New York AG exercised its authority to bring an action to enjoin violations of federal law. And so they joined on saying that, pursuant to that, they were bringing for a violation of the remittance rule. And the remittance rule plays a particularly important role in this case because it sets forth requirements for these fund transfer companies, what kind of disclosures they have to make regarding the transfer. And in this case, the complaint highlights that MoneyGram violated that rule by failing to include an accurate date of delivery in its disclosures. And they also alleged that MoneyGram failed to follow pertinent error resolution provisions of the rule relating to mistakes that happened during the transfer process. Now, MoneyGram, this is not its first rodeo with federal enforcement authorities. They've previously been in the FTC's crosshairs back in 2009 for fraud allegations and agreed to pay $18 million and to implement a pretty stringent anti-fraud and agent monitoring program similar to some of the ones we've talked about. Ultimately, the FTC pursued them for failing to comply with that order, and they wound up having to pay a much larger penalty of $125 million. Then in 2012, MoneyGram forfeited about $100 million to the DOJ and had to admit that it criminally aided and abetted wire fraud and failed to maintain, an AML program. Now, another interesting facet of this case is the CFPB's prior touches on MoneyGram. The complaint details that MoneyGram was the subject of repeated CFPB examinations in 2014 and in 2016, both of which highlighted a lot of the issues, a lot of the failings and the disclosures that are set forth in the complaints. And that when the CFPB went back in 2019 to check to see whether, the findings of their examination and their recommendations had been implemented at MoneyGram, none of them had been. And so the CFPB seemed to be particularly ticked off that they had essentially given so many warnings to MoneyGram, and MoneyGram had not heeded those. And so I think it's pretty obvious to say, but if you get enforcement attention and you don't make the changes, you can't expect that they're going to, forget about you. And that's seen both through the CFPB filing this lawsuit, as well as seeing how MoneyGram faced a contempt order for failing to comply with the order. And next, we're going to transition to talking about red flags in common red flags that we're seeing, and I hope that the cases that Len and I've talked about today kind of already put in your mind a lot of the red flags, because I think these are kind of recurrent themes that we've seen. But when you're in the onboarding process as a payment processor, what should you be looking for? What should you be flagging and paying close attention to when you're evaluating a merchant? As with Brightspeed, looking and evaluating whether your merchant is engaged in a high risk business. And as Len said, using RCCs, that should set off a trigger. Outbound telemarketing, another trigger that your merchant's in a high risk space. Law enforcement or previous regulatory actions against a merchant, that's going to be front and center in an enforcement agency's complaint against you. If you saw, particularly if the regulatory or enforcement action had to do with the product or service that you're going to be processing payments for, that's going to be a really big red flag. The EPS case is a good example of a deficient merchant application being a red flag. What business or product or service is the merchant selling? You have to be able to understand that. You have to be able to explain it, and you have to be able to justify why you thought that was not unfair, not deceptive, not violating the law. So it's really important to make sure that your merchant is filling out that application fully. Similarly, red flag, if you see one merchant opening up a ton of different accounts or locations, but not really showing you that they're operating and providing a bunch of different services, that can be a sign of fraud. And then the regulatory agencies do look a lot at the financial viability of account holders. You should be doing a credit risk assessment of new merchants that you're considering bringing in, looking to see whether they have large outstanding debts. What are their credit scores? Have they had other businesses that have gone into bankruptcies? And finally, it's very important to review your potential merchant customers' marketing materials. Look at if they're selling something on a website, look at the website. Look to see is the website confusing to your compliance personnel? That's a bad sign if it is. Does it say that it's a free trial, but then the disclosure says it's actually $40 a month? You should be looking at that with a very discerning eye. And then what are the common red flags once you've onboarded a customer? When you're doing your due diligence, you're monitoring and you're screening the accounts. If you later come to find out that there was a fictitious owner, if when you're redoing your know your customer requirements, if you're re-upping that and you see that you don't have a business license, you don't have a driver's license, those shell companies, straw owners, huge red flags. Load balancing. So if you see that your merchant is taking transactions and spreading them across multiple merchant accounts, that may be a way for them to try to hide some of those high chargebacks or odd transaction issues. Excessive chargebacks or cancellations. I think that's probably something we saw in every single case we looked at today. As Lynn said, the FTC and the CFPB, they're taking really aggressive positions about when you should investigate. So watching those, monitoring them probably on a monthly basis is a great key place to go. High levels of consumer complaints, whether you're receiving them from your banking partners or if you're finding them on the Better Business Bureau website or public complaint boards, you know, those complaints, regardless of their location, are big red flags. And then finally, discrepancies regarding transactions. You know, if there's weird issues with where the date and the amount seem to be different from what the customer authorized, that's also a red flag. And Len, I'll turn it back over to you to talk about some best practices to avoid these red flags.
Thanks, Mary. Before I do that, I just wanted to follow up on a couple things. The MoneyGram case is a good example of the approach that the CFPB is taking now. They've expanded their examination authority over non-bank entities. So they're going to use that to do pre-complaint discovery, essentially. And they will make, they'll indicate, matters requiring attention, MRAs. And you really need to take those seriously if you're subject to those, because if you don't, you're setting yourself up to be sued, and not just sued, but perhaps having people at the top of the company sued in their individual capacity. If you read the things that Rohit Chopra has said, if you go to their website, you can find a speech he gave at the University of Pennsylvania Wharton School, where he talks about, when he was at Wharton, he thought most businesses were slightly corrupt, and the people who worked in the government were similarly corrupt, just waiting to try and position themselves to go work for the corrupt businesses. So that gives you a little bit of his worldview, and I think directs you to be especially careful when dealing with that agency. You can look at the statements that he made in his press release regarding the MoneyGram complaint announcement and the TransUnion complaint announcement, where he made very strong statements about the need to send, that he had concerns about recidivists, and that the only way to stop that was to start going after individuals to stop the recidivist behavior. So be careful. On load balancing, the FTC, the CFPB take a really sinister view of load balancing. I've had numerous discussions with folks at the agencies about this, and we've taken the view that how is having multiple merchant accounts any different than having multiple lines of credit? And the stock answer that we've gotten back is they can see no legitimate reason for multiple merchant accounts, even if companies using to track lead sources or that the company can only get so much processing throughput with one one processor, and then so they want just like with bank, where you might only get $10,000 from one bank, you go to get $10,000 from another bank, or multiple credit cards if you're starting a business and you max out a bunch of credit cards. But multiple merchant accounts and balancing among them is viewed very sinisterly, and especially if it looks like the company is doing that to keep their chargeback levels below the chargeback thresholds, it's going to be really suspicious. The more the processor is involved in trying to make sure that chargeback thresholds aren't tripped among multiple merchant accounts, that kind of load balancing, that is a thing that gets processors in trouble lots of times. All right, now to what I'm supposed to be talking about, best practices. Culture of compliance. I mean, it's got to be from the board down. Policies are really, really important. But one of the worst things that you can have are to have really strong policies and really weak follow-up to those policies, because the enforcement agencies will take the position that your failure to follow your own policies is evidence that you're acting unfairly. The CFPB has taken the position that if you're not following the Visa or MasterCard rules, that in of itself can be evidence, essentially almost de facto, proof that you are acting unfairly. So it's, policies and procedures are great, but you've got to maintain them. And if they're not something that you're following or not something you think you can follow, you've either got to try harder or adjust your policies so that they're realistic, because having policies that you can't follow is really dangerous. But again, given the attitude of the enforcement agencies, they are looking at processors as essentially guarantors for the merchants. So you really do want to be careful. They want to know where the money's being spent. Are you investing in having technically competent, technically sophisticated systems and people to manage screening and monitoring? Record keeping, we've talked about this before, but if merchants are getting tricked by your screens or your other methods of either screening or monitoring their behavior, you have to have really good records of what was done and why that merchant was either boarded or kept. The failure to do that leaves you with a record where you've got questions being asked, concerns being raised, and a lack of evidence of how those issues were resolved and why that merchant was allowed to either come on to your platform or stay on your platform. So it's vital that what you're doing is documented, and who's making that decision ultimately is documented, so that you can ask that person, if you need to ask 2 years later, why was this done? Obviously, you need to be careful up front, screening prior legal actions, someone who's bouncing from processor to processor, scrubbing their marketing, making sure that they're not sending you just a quote bank page as to the page that they're using to show the credit card companies, but actually the page the consumers are seeing. You want to compare those two. You want to look at their credit risk, obviously do the necessary OFAC and KYC stuff, but you really should understand how the companies that you're onboarding are marketing their goods and services to consumers, because you may have to explain that someday. Mayor, next page, please. It doesn't stop once they're on your platform. You've got to do monitoring. Are you seeing explosions in volume? Are you seeing explosions in chargeback or cancellation rates? Are you getting consumer complaints? Are you reading the narratives that accompany chargebacks, at least some of them? Are you making sure that the company is still where it said it was? Are you making sure that if they opened as a bookstore, they're still selling books as opposed to nutritional supplements? And biting the bullet and terminating bad actors, because if you have concerns and those concerns are raised and you do not do anything, you're essentially making yourself the guarantor as the payment processor for harm that the merchant may be causing to consumers. All right, next slide. So how do you end up on the agency's radar? Well, they track. So when they're looking at quote bad merchants, one of the first questions they're going to ask is, who's your processor? Who's your ISO? So if your name keeps coming up with companies that the FTC or the Cfpb or the state AGs are suing, you're going to end up on their screen. The merchants may roll over on you and say, hey, all these multiple merchant accounts, that the processor told me it was all okay. Typically, if the FTC starts to look at you, the Cfpb starts to look at you, you get a civil investigator demand, which is essentially a subpoena asking you all kinds of written questions, documents, may ask you to testify. Those are getting harder and harder to respond to, more and more vigorous, and they're less and less cooperative in narrowing the scope of the CIDs or in extending the time within which you have to comply. If you get one of these, you don't want to just answer question one, answer question two. That's it. You really want to start telling a story from day one to try and position yourself to have as positive an ending to the inquiry as possible. You can petition to quash the CIDs from either agency. They're not terribly successful. Every once in a while, they'll modify the CID in response to that, but they don't quash them. You make the petition to the agency that issued it. You can then force the agencies to go to court to compel compliance with the CIDs. Courts grant them. Sometimes they take a long time to grant them, but if you're going to go that route, you really want to make sure you have a strategic reason for doing it, because you're creating a lot of bad will, which will make it harder to resolve ultimately. We are at the end of our hour. Again, the CLE code is Compliance 2022. I know there were a couple of questions. I apologize we did not get to those. We will reach out to you folks if we can answer them. On behalf of Mary, I want to thank you all for attending today. Look forward to speaking with you again soon. Hope everybody has a great weekend. Thank you.